filed a petition on Friday last. Some address is there because my college fund has been shifted to another college level by the new MLA, where the foundation stone was also laid down. So one is may kindly be listed tomorrow morning.
Day after. When is it?
Item number 49. On item 46, we have instruction losses. Matter is similar losses. For 10 days, 10 days time. 46 to 49.
46 to 49.
For 10 days time.
Who's for the petitioner? Any objection? 46 to 49 on the request of the Council for the Higher Education. Mr. Yeah, stand referred to listed after 4 weeks. Mr. So-and-so appears.
For admission on Wednesday.
Wednesday is difficult. You can have it on 29.
I have also similar pair, but next week.
29.
The lordship there for listing of a matter for withdrawal.
For
of like. For listing a matter, admission column.
admission. Let us have it in August. 3rd August.
Right.
Yes.
Also, with regard to item number 13, your lordship, we have lost touch with the petitioner, lordship. Therefore,
You have?
we have lost contact with the petitioner, your lordship. Therefore, we are praying for 4 weeks' time to obtain the instructions from the client. Praying on behalf of Ms. Devi.
Item 13 on the request made by the Council for the petitioner stand referred to.
Lordship, similar to item 55 is there.
Same ground.
Lordship, same ground.
55. Third August.
Please, Lordship, I recommend item number 37. In this matter, the affidavit in opposition has been filed, and we want 3 weeks' time to file the rejoinder.
30. Item
37,
number
37.
37.
Yes. Lordship, and there is also an interim order that.
You are for the petitioner.
Lordship.
Your name?
Lordship, A. Hazarika.
E. Hazarika.
A. Hazarika.
A. Hazarika. Council for the petitioner prays for an granted 3 weeks' time to file rejoinder. Remote needs 10 again.
I beg to mention item number 24.
24.
The council has some personal difference.
Item 24 on the request made on
My
behalf of
lord.
the council.
My lord.
Petitioner stands deferred to be listed after
Matter may be fixed at 2 p.m.
2 p.m. Right. Then you don't need a mention. 2 p.m. 24 to be called up at 2 p.m.
Always, my lord.
Yeah.
I beg to mention item 43 for adjustment. As my LRS is out of state.
43 on the request made by the council for the petitioners. Then you are for the petitioner.
No, I'm for a petitioner, my lord.
Oh,
So, the case is very urgent because my lord, her as the task status has been rejected by the SLC, my lord. Now she is holding the post.
who you're making a mention on whose behalf?
Lordship, I'm on behalf of PD.
Huh?
PD.
So they are objecting.
So kindly it's a short date.
Friday?
Lordship, can it be on 31?
Yes. Oh. What is the short date? You tell us which date.
Next week, Tuesday.
Next, not Tuesday. Why Tuesday? 22nd. So today is 21, 29. 29. You wanted it next week, Tuesday. We are giving you 1 day after. 29. Yes. Item 43 on the request made on behalf of respondent council stand paper as agreed to by the council party, please take in on 29. Yeah. Item 53. Item 53 Stands deferred to be listed in the part 2 hearing list.
With respect of item number 16 and 17, I have to file a reply for the newly inflated private respondent. Can it be after 2 weeks?
You are for the respondent.
Yes, sir. For a
Who's
respondent.
for the petitioner?
I am appearing for the petitioner in both the cases.
Any objection?
I appear for the respondent of 4 in item 17.
Item 16, 17 on the request made by Mr. M. Counsel for appearing for respondent.
Respondents number 5, 6, 8, 9, 17, 12, 13,
Okay,
14.
give the list. Submits that you'd like to file counter affidavit. Counsel for the petitioner, the floor of the made. Mr. E. Das appears for
Respondent number 4 in item 17.
respondent 4 in item 17. Mr. Bora for appears for SC.
ERT.
What is CRT? SCRT. Standing counsel SC.
Can it be on the 7th of August?
First file it,
Sure.
then make a mention.
Sure. All right. All right.
Yes. Huh? What is the status of the appeal? Some appeal was filed.
Some appeal is pending.
What is the number?
Appeal number also. Read appeal number 309.
Oh. Of 25. It is submitted by the counsel appearing for the BTC. Mr. B.C. Muzari, that the writ appeal being writ appeal 309 of 25 is pending. Since none represents the writ petitioner, matter stands deferred to be listed next week.
The last occasion, in spite of a specific direction passed by this honorable court, direction was given to them to take the necessary instruction, whether the physical verification are done.
You are praying for what? Regularization?
For
Let-
provincially.
We'll issue notice, let them file their response. How the petition can be disposed of on the basis of instruction. Mr. S. Chaudhary, petitioner, MSP plus APS for
1, 2, and 3.
respondent 1, 3. Therefore, notices, formal notices of 1, 2, and 3 will be waived. However, extra copy will be furnished within the period of 3 steps of respondent file by registered speed post within 1 week. Respondent will complete their instructions and file that same.
Your Lordship, instruction received, Your Lordship.
Instruction received.
Yes, sir.
What is that instruction?
Your Lordship, it was said that due to he was prior to his retirement and he submitted the seniority list of the teaching staff of the school to the office of the undersigned white letter so and so dated on 9/3/2026 for consideration of selection of the next principal in charge. On receipt of the said seniority list, the undersigned forwarded the same to the DSC Education for necessary action regarding the selection of the principal in charge, white letter dated so and so on dated 9/3/2026. The said communication was received in the said office DSC Assam on 11/3/2026. However, instead of issuing an order appointing a principal in charge from amongst the eligible teaching staff of the school, the basic was forwarded seniority list to DSC Assam on dated
2026 directed the Inspector of School Nagaon to function as the principal in charge of PM Sri Rupohi Higher Secondary School with effect from 1/4/2026, along with financial power to draw and disburse the salary of the staff and to exercise other power as specified in order. In that issuing that order, Your Lordship, for the functioning the institution continued without any interruption. The undersigned issued the following temporary administrative order, which was issued that order number so and so dated on 9/30/3/2026, whereby Shri Kushal Gayan, graduate teacher, PM Shri Rupohi Higher Secondary School, was directed to look after the academic affairs of
Bring it on record. Bring it on record. But counsel for party. Yes. Spending council secondary instruction doesn't see. It's permitted to be seen.
this instruction received from the Inspector of School, Your Lordship.
Bring it on record. Since the standing council appears for spot one. Steps on respondent four by speed.
I'm deeply obliged.
Yes. What is your remand?
Even if my lord, I'm the behavior losses of the EDA, the Higher Secondary School. He suddenly fell ill, man. He suddenly fell ill, which is my lord typed with serious others problem, my lord. And my lord, we have made a prayer before the authority concerned for commuted leave. But the authority, my lord, did not grant commuted leave instead of extraordinary leave without pay granted, my lord. And my lord, while forwarding letter, your lordship will find annexure 9 at page 30, my lord.
Any instructions?
No, Your Lordship, instruction awaited, Your Lordship.
Then get your instructions.
Yes, sir.
Now, Mr. Losber.
Fine.
Mr. Losber appears for the petitioner and Ms. Vidas for the response. She gave the instructions. Release this matter again after 2 weeks.
Notice issue one.
2 weeks. We are not issuing notice.
Yes,
Get the
sir.
instructions. Let us after 2 weeks.
Fine. All right.
I'm deeply obliged.
Whatever my lord, petitioner due to severe medical condition, mental distress, then comes
This we'll have to issue notice.
and then there may be.
What interim?
My lord, the court is still vacant, Your Lordship. So
Right.
that may be vacant, Your Lordship.
Council for the parties issue notice. Returnable 4 weeks. MS Sharma.
Madam Sharma.
M. Sharma appears for
1, 2, and 3, Lord.
1, 2, and 3. Okay, extra copies will be furnished within a period of 1 week. Steps on respondent number 5, 4 by speed post. Petitioner, it is submitted that the petitioner, because of severe medical condition, was unable to continue his duty. You have submitted a resignation letter. Then was it withdrawn?
Not by lord, it was
Then-
accepted.
Then
Your Lordship. Your
if
Lordship.
your resignation submitted, whether it is accepted or not, we don't know, but at least from your side,
At the
there
time,
has to be a request for withdrawal.
suffering from mental distress was not voluntary. Your Lordship.
Is released again after the returnable date. We can't give an interim order like that. You have submitted resignation.
Post is still vacant, Your Lordship. That is why.
Maybe, but if you have submitted resignation for that post, then you will have to withdraw your resignation first, subject to the same not being accepted as on date. You have not withdrawn it. If you have not withdrawn it, then you have already submitted your resignation. Get your instructions from the client. And it pays for it.
Sir,
Yes.
objection is that you will not be entitled to relief he or he is seeking, unless he includes Department of Education, Union of India, National Institute of Education Planning and Administration. That National Institute of Education Planning is the department, madam, where
First, let us issue a notice. Let us issue notice, let him
Second.
file your objections or whatever.
Not-
You're raising questions of maintainability for non-joinder of proper parties. Third counsel for parties, Mr. R. Islam is a legal aid counsel. Issue notice.
Then, my lord, I may be allowed to fresh. It's better.
Mr. R. Islam, legal aid counsel, submits that he'd like to withdraw the writ petition as certain part respondents were inadvertently left out the arrayed as parties. And here certain some respondents were not arrayed as parties by oversight. Takes leave of the court, file a fresh writ petition with the necessary corrections. Prayer made is allowed, not objected to by the counsel for the
I'm paying for respondent number 2.
respondent. And
158.
the respondents matter stands dismissed on withdrawal.
Much.
So in this case, Lordship, I am challenging the order dated 30/01/2025, whereby the respondent number 4 was allowed to hold the charge of principal in charge. And subsequent also speaking order dated 04/04/2026, whereby said action was affirmed. In this case, Lordship, the petitioner is senior graduate teacher of Noga Government Girls Higher Secondary, and the respondent number 4 is junior to the petitioners. Lordship, here in this case, Lordship, earlier we have filed one petition, and regarding that petition, the Honorable Court direction consider the representation which is submitted by the petitioners, and that representation was subsequently disposed of, and the speaking order was passed.
Where is that order?
Speaking order is annexure number 2,
Page 1.
page number 23. So only in this case, Lordship, only the petitioners, Lordship, they obtain their master degree without taking prior permission from the authority during their service.
No, out of the 3 petitioners, who is eligible to be a
Respondent number 4.
principal in charge?
Lordship, kindly see that page number 25, the gradation list, annexure number 3, Lordship.
Page 4.
They are the senior, Lordship. The 3 petitioners are seniors.
No, but out of these 3 petitioners, only 1 will be allowed.
Yes, Lordship.
So why are the other 2 petitioners also making a claim equally? Petitioner number 1, if she is allowed, then 2 and 3 will have no claim.
I understand, Lordship. But
Why are the 3 petitioners before the court?
Lordship, the petitioners are senior. They are the 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 senior.
There's only one post,
Yes, sir. Only one.
one person. So you are agreed by the appointment of respondent number 4. In that place, in the place of respondent 4, either 1 or 2 or 3, but not all of them.
So the representation which is submitted for the respondent authority, they have filed jointly.
Maybe. But your claim before the court is only in respect of only one person. Only one person can claim. They have taken master degree without taking permission.
Yes. That must not be.
Is it a ground to the? I mean, are their degrees not recognized? Department?
Your Lordship, they have to take prior permission, Your
Right, they
Lordship.
did not. Are their degrees not recognized?
Nowadays, it is mandatory, Your Lordship, as per rules. Your
Not
Lordship.
getting the point. They've already taken their degrees. It is not a case that they're pursuing their degrees. If they're pursuing their degrees without taking permission, you may take action against them. But they have obtained their degree. Now, once the degree is there, can you ignore their degrees merely because they did not take permission? Get instructions, heard counsel for parties issued notice written of MSP that appears for respondent 1, 3 steps on respondent. Start to the return opinion.
All right.
In this case, the petition is headmaster and the promotional estimate it's some complaint was aroused between the headmaster and the committee member. He was suspended. Subsequently, he was reinstated, my lord. But in the reinstated order, my lord, the one penalty is imposed. My lord. Only that part, my lord, we approve this on the court.
What penalty?
Penalty, my lord, relevant part, my lord.
You go in appeal? Why have you come to the court?
We approach the authority, my lord, regarding the my lord, penalty part, my lord. But they are not any extra positive step, my lord.
Where is that?
My lord, page 24 and relevant part, my lord, penalty part, page 25, my lord. My lord, only to discuss the misbehave of the school managing committee and the petitioner being a headmaster, my lord. On that ground, my lord. Page 25, my lord, penalty part and reinstated part, my lord, page
So
20.
where have you filed your appeal? Did you file any appeal? Is there any appeal?
But we are not filed the appeal, but we approach the authority, we submitted the representation.
Where is that?
That, my lord, cannot annex this part, my lord.
This is under what provision? Under what provision? Discipline and appeal.
Discipline appeal, my lord.
So there is a provision for appeal. Go and file an appeal. File an appeal. Why are you coming to the court? Only for this purpose.
Penalty part, my lord.
What ground are you urging the penalty?
My lord, the hearing procedure, all the things, my lord, is related, but the authority also we approach to provide the area of the salary, my lord. That area of the salary, the penalty part not to area of the salary, my lord. We approach this area of the salary, my lord. Area of salary part, my lord. Yeah. The suspension period, my lord, we get 50%. Rest 50% salary yet not paid, my lord. The statement, my lord, kindly similar the statement issued by the my lord
DO, block elementary officer, my lord. That period, my lord. Area salary, my lord. Case 26, my lord. Regarding my lord, especially my lord, we approach the first, my lord, the non-payment of the arrears, salary of the suspension.
No, but the order says that you are reinstated. Suspension period shall be treated regularly.
Yes, my lord.
Only for pensionary purpose.
But that period, my lord, suspension period, my lord, the area will be 50% we get and 50% less.
And he shall not be eligible to draw the remaining subsistence allowance. You are agreed by this?
Both the, my lord, but area of the suspension period, my lord, 50%, that part and that part.
There is some area you are required to be paid.
Yes, my lord.
That has not been paid.
Not paid, my lord.
And then
Then, my lord, we approach the authority, my lord, to pay this area, my lord.
what other claims do you have?
And secondly, my lord, the second part, my lord, the in one annual increment, that was the
So you are challenging the imposition of penalty also.
penalty also, my lord. Both, my lord.
You should go and file an appeal.
Regarding, my lord, the
What is the ground for challenge?
my lord, regarding my lord, area salary part, my lord.
Is your challenge for the appeal, for the imposition of the punishment? What grounds?
Basically, my lord, my lord, regarding the suspension period, my lord, that period the regularization. But regulation period is not paid by my salary.
You are also challenging the imposition of punishment, or you are not challenging it?
Both should be challenged.
And then we are asking you, what is the ground for challenge? Why should we entertain your petition? On what grounds are you challenging the imposition of punishment?
Punishment, but regarding my lord salary.
Then will record your submission that the writ petition is only seeking a direction for release of the areas.
Yes, my lord, that part, my lord.
Only that part.
That part, my
We
lord.
heard counsel for the party. The writ petition is filed by the petitioner seeking a direction. Respondents. Seeking a direction for interfering with the imposition of the punishment or a penalty or stoppage of one increment.
Both sides.
Setting aside impugning the reinstatement order, it's
What-
there.
What? In respect of the
It's praying for setting aside the quashing of the impugned order dated 8/12/2022. The extent of imposition of the penalty or withholding of one annual increment with cumulative effect under Rule 7(1)(2) of the Assam Discipline and Appeal Rules, 1964. Stop further prayer is for a direction for release of the arrears of the subsistence allowance payable to the petitioner. Stop. However, during submission before the court, the counsel for the petitioner submits that at present, the petitioner's prayer before the court limited only for seeking a direction for release of the arrears of the subsistence allowance. Does not wish to press the prayer for interference with the imposition of penalty by the impugned order dated 8th of December 2022. In that view of the matter, the respondent counsel will obtain the required instructions in the matter as to why the arrears of subsistence allowance has not been released to the writ petitioner. Released after 4 weeks. Mr. Bushari for
and for respondent number 2, 3, 4, and 5.
2, 3, 4, 5 is Sutia for
One.
1. Hazarika for 6. Although notices are not issued, extra copies will be furnished. The respective counsel appearing to respondents within 1 week. After 2 weeks, date 7th. August.
Petitioners proposal achieve for non-release of area amount of MSCP. The petitioner number was appointed in the year 1983. And thereafter, my lord, he has retired. Retired on 30th of November.
Will issue notice here. Third council for party issue notice that study the open.
Correspondent 1, 3, 4 and 5.
1, 3, 4 and 5. And it's Nazarika for respondent number 2. And since the respondents are represented, formal notices not be issued. However, extra copies will be furnished within a period of 1 week from today. Steps on respondent 6 by speed post within 1 week.
Right.
So, Lordship, the case of the petitioner is the petitioner is the husband and nominee of Srimati Bula Sarkar, who actually died in who actually retired from on 31/1/2022 from service under education as a subject teacher of Bijni Bandhab School as under the respondent number 2, that is education of Director of Education BTC. After that, she was legally entitled for the provisional pension, which was sanctioned, that is in annexure number 1, page 18. It was sanctioned that the provisionary pension for rupees 39,000 per month. After that also, the pension was not released to her and she made representation. And then on annexure number 3, that is page number 20, Your Lordship. So it was sent by the respondent number 5 to the respondent number to SDO for counter signature, and a bill was prepared of rupees 3 lakh.
Third council for party should this return Mr. Mushari. 1, 2, 5. The accountant general, any counsel here? Mr. B. Chakraborty appears for respondent 3. And who's for pension? S4 appears for director of pensions. Says on respondent 1, 2, 3, 4, 5 stand waived. However, extra copies will be furnished within a period of 1 week. Steps on respondent 6 by speed post within 1 week from release start to the return date.
Your Lordship, humble submission instructions will be obtained about the area amount of the sanction amount.
We are issuing notice, let them obtain instructions. They will obtain instructions.
Much.
Well, the similar series matters are pending, my lord, and WBC number 273725. And there was no issue notice in the similar matter. But they, my lord, as the issue is same, and not.
Yes.
Notice will be issued, my lord.
Third council for party issue. Mr. Ring Sharma appears for respondents number
1, 2, 3, and
1, 2, 3,
1,
4.
3, and 4.
All the
All the
respondents.
respondents.
Submitted that is similar matters are pending before this court release this matter after the returnable date along with WPC number
My lord, 2737,
737 of
2025.
25.
2025. My pleasure. Presentation is covered by W number 345 of 2025. We're seeking for similar direction.
Ah. Good. Yes, we have disposed of some matters. Have you
352123.
3, 5,
21.
1? Third council for parties disposed. Slide number.
Mayor, please. We going on 11/6/2026 took 2 weeks time for instruction. The
Yes.
next matter was registered on 15/7/2026. Admitted was absent.
Yes.
Because we seek some more time, this short time. We took the consent of the petitioner side today. Any short date will after. Because it's a little old matter. Needs some time to
On the
take it.
request of the counsel for the respondent. Request of the counsel for respondent, matter stands deferred to be relisted again on 3rd of August. Enabling them to obtain the required instruction, Mr. B. Rahman appears for the writ petitioner. Released on 3rd of August.
Right. Well, here I need some time, 2 weeks time may be granted, my process of verification is on, my lord.
Lordship, last time also, Lordship, last chance has been given to respond.
My lord, we are in the course of complying this order of the honorable.
How much time? Give us a specific date.
2 weeks time, my lord.
Weeks for the time.
1 week.
So the time is prayed for by the standing counsel. Elementary education, Mr. Deborah. Submitted that the verification process likely to be completed within the next 2 weeks. MS
Okay, fine.
A
Fine.
filing appears for the writ petitioner. Released again on 7th August.
Obliged.
Sorry for interruption, my lord. I have got some mistake, my lord, in respect of item number 6 and 12. Both the cases belong to me, my lord. But I have confused and wrongly written in my note, my lord. So, my lord, item number 6, it has have, I could not appear. Item number 6, my lord, it will be similar to the item notice. And item number 12, my lord, it back in.
Wait until.
Yes, item 6 and 12.
Roll up again.
Yes.
You inform the other side.
Yes.
Yes.
It is a matter for compliance, my lord. They have not done it since the judgment was passed 2024. All the time they are taking,
Where is the order?
lordship will find the honorable court's order, relevant portion. Page 35, minute. 35. Page 35, para 8. Basically, para 10, 2, 2, 3.
This is a review petition.
A review petition, even the petitioner and the respondent number 8 has been accommodated by this honorable. Earlier occasion, the respondent number 8 here, respondent number 8, the review petition got the order from the honorable court, and accordingly, my case was considered. But subsequently, when review was filed, the review also, the review petitioner case has been considered, as well as this respondent number 8. Since there was a post, and accordingly it was directed to consider the case of both the petitioner and the review respondent number. Now, since 2024, the matter is pending, and all the
No,
time,
where is the direction?
lordship, page 36, lordship, kindly have a look. This is para number 10, subclause 2. This the respondent number 8 would
The
now be
review was allowed.
allowed.
It was allowed.
Review. Three, 4, 5, my lord. This para 1, 2, 3, 4, 5, 6, 7.
Madam, in this matter, we are going to file appeal, madam. Madam, sometime at the end.
That is not a ground. When was this order filed, passed?
It was passed in 2024.
2 years you are still going to file an appeal? Not a ground.
Last month, may be granted.
No, what last chance?
And that too consenting order after taking the consent from the council of the opposite party, the standing council of the education. This accommodation has been made by the honorable.
How can you file an appeal now? Para 8. Come to para 8. Yes.
Yes,
Consent order.
the setting, the position and considering the agreement arrived at by and between the parties is court not further proceed to consider the issues arising the review petition, but with the whole we are given the materials available on record, particularly the dates of joining in their services by the original petition and the respondent number 8. It is to
No,
be
no,
helpful.
we are only trying to
Yes, consent both the parties.
bring it to your notice that it is a consent order.
Yes.
There is a scope for an appeal. You have been given 3 months' time. You are already in contempt.
But my lord, subsequently we came to know that he has not attend his classes and further, and we have in this regard we have filed our affidavit also. Director filed the affidavit here.
In this petition.
Yes,
No.
in the contempt petition.
Yes.
So in this here it is stated that subsequently a hearing was conducted on 10/9/2025 in respect of Lukman Ansari, respondent number 8 in the review petition number 106 of the 2025 and the respondent number 4 WPC 4729/2021 in the office of the Director of Secondary Education Assam, where the inspector of school as this is a school come headmaster of Srimati Sandapova Pandit Smriti Hindi Vidyalaya Sunitpur district and Lukman Ansari were present. In the said hearing, the documents regarding the educational qualification in respect of Lukman Ansari were examined to absorb him in the post of Assamese language teacher in the in Srimati Sandapova Pandit Srimati Hindi Vidyalaya. In the course of hearing, it appeared that the petitioner Lukman Ansari has not possessed the requisite educational qualification for the post of Assamese language teacher, neither under the Assam Secondary Education Provincial School Rules 2003 as amended 2012, nor the Assam Secondary Education Provincial School Rule 2018. Further, regarding the 8-year salary of the petitioner Lukman Ansari as assistant teacher in Srimati Sandapova Pandit Smriti Hindi Vidyalaya, Sonitpur district for the period of 1/9/2020 2014 to 15/9/2021, it is observed that the petitioner, that is Lukman Ansari, was not discharged his duties during the aforesaid period in the school
as his name was not reflected in the UDA's data of the school in the year 2014, 15, 2016, 17, 18, 19, and 2020. As the UDA's data is the most acceptable data from where the presence of teacher in the school shall be ascertained. However, the aforesaid aspect was not placed before the Honorable Court at the time of hearing. And as such, it is requested to the Secretary Government Department to provide appropriate instructions.
At the time of hearing, all this matter has been taken into consideration. And this, since it is not a fresh recruitment, now the petitioner has already been retired as an assistant teacher. This is just accommodation that has already been taken into consideration.
Was this, they said it is not placed before the court at the time of hearing.
Yes.
Now can this ground be taken after 2 years, my lord, of passing the order?
No,
Had there been anything else?
no. Is
Nothing?
it see, there are two things. One is that there is already a decision as to the eligibility of the petitioner. That decision is already taken by the court. Therefore, no further question of trying to find out whether the petition is eligible or not eligible. If the direction of the court is giving some responsibility to the director to find out, and the director, after making an inquiry, finds that you are not eligible, then court can certainly look into this aspect.
Only here, my lord, this fact already been considered by this honorable court earlier. And here, my lord, this petitioner in earlier occasion got the relief from this honorable court, and in 2024, this review was filed by the respondent number 8. And I was appointed as the assistant teacher, my lord, in earlier occasion. And even they review the order, then I will be in the place, since my case was considered by earlier single bench, my lord. Even they review it, I'm entitled for the relief because of the earlier court's order, judgment in order. Now, just to accommodate this petition, this respondent number 8 and the petitioner, this honorable court passed this order, considering the situation and the continuation of the petitioner's service since 1990, my lord. Now I have already retired. In January, I have already retired. What more has been left out now, my lord, for them? And it is an agreement, my lord, between the parties. Had there been the first candidate, matter would have been different. Filing of appeal, there is also the time limit. The basis of limitation, the whole, whatever the grounds are there, will not be tenable under the law, under the Limitation Act. And they were the parties. Had there been any infirmity in the order, they would have come in the time.
Please take us through the order of this review.
This
Page number 30. Take us through the order.
is number 30. Yes. This order was passed on 27/6/2024. And before that, Lordship will find the order, my lord. In my favor, Lordship will find the judgment and order, my lord. Page 14,
Why,
Lordship.
why don't you take us through the review order?
Lordship.
You are filing contempt for non-compliance of this order,
Exactly.
isn't it? Take us through the order.
Yes, review order is this, my lord. 27/6/2024. Page 30. Administration, and Noenjyoti Khatuniya Lanit Standing Council, Secondary Education Department, appearing on behalf of the respondent number 1, 3, and 4. The review order, para 6, Lordship will find. Five and 6. The record was placed.
Yes. It's come to page 36, Roman 3. Read it, Mr. Sharma.
It is provided that the direction for provincialization of the service of the respondent number 8 here again against the post of Assamese language teacher is so passed by this court considering the unique facts and circumstances as arising in the matter, and the respondent authorities shall proceed to provincialize the service of the respondent number 8 against the post of Assamese language teachers as allotted to the said school by the order dated 2/9/2013, and for the purpose shall be considered as to whether the respondent number 8 would be entitled for such provincialization of his service against the post of Assamese language teacher, but shall so provincialize his service against the said post of Assamese language and release him release to him all dues and due service benefits.
There is a direction that should be regularized.
Yes,
Making
madam.
it very clear that will
He
not
was
consider-
supposed to absorb the post of Assamese language, but here the petitioners has not qualified.
is what we are want you to read it. It is clear in this order.
In that circumstances, one time may be granted so that.
What one time you first read it and understand what you are trying to convey to the court. Please read it again.
Yes. It is provided that direction for provincialization of the service of respondent number 8 herein against the post of Assamese language teachers is so passed by this court, considering the unique facts and circumstances as arising in the matter, and respondent authorities shall proceed to provincialize the services of the respondent number 8 against the post of Assamese language teacher as allotted to the said school by order dated 2/9/2013, and for the purpose,
And for the purpose.
yes,
Now
and
read.
for the purpose, shall not consider as to whether the respondent number 8 would be entitled for such provincialization of service against the post of Assamese language teachers, but shall so provincialize his service against the said post of Assamese language
It
teacher,
is
and
directed that you not consider whether he is entitled to be provincialized, but you shall provincialize. You agree, you should have gone in appeal or filed a review, but you have not. Therefore, comply. How much time you want to for compliance?
3 weeks may be granted. 3 weeks may be.
But we want your compliance. Don't come and tell us after 3 weeks that you are proposing to file an appeal. We'll draw up contempt proceedings against your director. We're making it very clear. Third, counsel for parties. The standing counsel.
I'm for the director.
The counsel appearing for respondent number
I'm for the respondent number 3, man.
3. Submits that there is a proposal to file an appeal against the judgment and order dated 27/6, order dated 27/6/24, passed in review petition 1/6 of 2021. Petitioner, the other end submits that this order having been passed in the year 2024, no occasion for the department of file an appeal, particularly when the order was passed as a consent order. I think there was the order itself, see that the court ordinate bench at para 8 said order and recorded consent between the parties for passing the direction contained in the order. As per the directions at para 10 in bracket Roman 3, it seemed that the case of the respondent in therein, namely the petition of this court, shall be considered for provincialization against the post of Assamese language teacher which was allotted to the school concerned and which is stated to be available. And is further directed that for that purpose, the authority shall not consider whether respondent 8 be entitled for such provincialization of services. So Assamese language teacher, but shall provincialize the same against the post of Assamese language teacher and release also. This being the specific direction, the order date is well so fast by the writ code. Action before the court now will look whether the order has been complied with. Or is required to be complied with. Respondents. So, Mr. Sharma has placed before has referred to the affidavit filed by the director to submit that the writ petitioner does not fulfill the required qualification specified under the relevant rules. And his charging is during the aforesaid period. School, as his name was not reflected in the UDICE, UDISE data of the school in for the year 2014, 15, 16, 17, 18, 19, and 20. However, these facts were not placed before the court at the time of hearing. In spite of such clear averment in the affidavit, state has not taken any steps filed any appeal or review taken part. Therefore, at this stage, the question is whether the court should draw up contempt proceedings against the respondent for willful disobedience defiance of the directions contained in the order. So, directions that para 10 in bracket Roman 3. Speech the State Council prays for time. Considering the prayer made, trying to permit state to further 3 weeks time to comply with directions contained in this order. Release this matter again on 19th of 19 August.
For compliance. For compliance.
We are hoping they will comply. We will not have to draw up contempt proceedings.
Maintain is the authority part.
Where is Mr. P.K. Bora? He has filed the wakalat on behalf of the respondent. Mr. Evzed Mazumdar comes in for the petition. By the last or by the earlier order dated 9/6/2026, Mr. P.K. Bora P.K. Bora's name is recorded in the order as counsel representing the sole respondent. So, matter is called up. Mr. Bora is not yet with justice. Matter be revisited next week.
Can I pray for a date?
29th. This thing will reflect the name of the council. Department. Please inform Mr. Bora, we are fixing it on 29th.
Madam, item 19, madam.
Yes.
In fact, in item 19, madam, we have received an instruction, madam. With requesting for submission of non-royal certificate for 26-27. That is not given by the district office, madam. Now we have sent a reminder to them, madam. Will be fixed after 2 weeks, madam. In the meantime, we'll obtain it.
Yes.
Last week of the August.
12th of August.
Yes, madam.
Can I have a copy of it?
Yes. I'll provide it.
Between the two of you, nothing. Share your instructions or not.
Right.
Yes.
Obliged.
Dated 10/6/2025, 26 months. Recently directed to obtain instruction in the matter within 2 weeks, and accordingly, today's date fixed.
Yes.
But in the cause list, Mr. Assembly's name is not shown. Maybe instead showing his name, maybe he has not.
In fact, my lord, Mrs. C is not available today, my lord. For this entire week, he is not available. So, my lord, may fix it the first week of August.
Already after 2 weeks, they stayed after 1 month. Can it be within this month, my lord, a specific date?
Of the request made on behalf of Mr. SMT Chisti stated to the council appearing the respondent, both the respondents.
He was directed to obtain instruction on behalf of all the respondents. From them.
Matter stands deferred instead of 31st, like Mr. UK Goswami, council appears. Released on 31st.
But the name of Mr. SMT still may be shown in the call.
You communicate it.
Obliged.
Order complied,
Not complete.
not complied. Why these orders are not being complied with? Don't compel us to issue notices against all the departmental officers. If the orders are not complied, then we'll have to take some steps. Orders are not meant to be passed and kept in the files.
It's a fresh case, my lord. I'll obtain instruction.
What fresh case? The judgment was delivered on 12/12/25. What do you mean fresh case?
But
Does it require a contempt petition to bring it to the notice of the department that the order
No,
requires
madam, no.
compliance?
certainly not, my lord.
Then these matters are all disposed of in the presence of the state council.
Yes, ma'am.
Where is the direction here?
Only direction at page 55.
6 weeks. Any appeal file?
Nothing.
No appeal file. The council who appeared, Mr. B. Kaushik,
It's during. Give me some time so that I can obtain instruction regarding compliance with that.
no application filed for extension of time. Director Elementary Education will, council appearing for the Director Elementary Education will apprise the court as to why the directions contained in the order dated so and so passed in the so and so has not been complied. Relist this matter again on 12th of August. Mr. B. Forecast here for the record.
But they have filed for implement in IL last occasion I have objected also.
Implement of,
Response
whose implement?
they have filed.
I filed.
It's unnecessary for.
You have filed. Okay. You are for the,
But a principal of Gauhati College.
huh?
Principal of Gauhati College.
Principal,
In charge.
in charge principal. What is the issue in the writ petition?
We have challenged the outcome of the disciplinary proceeding. We have removed from the service, then we prefer appeal. The commissioner and secretary rejected our.
You are not the
Not
disciplinary
necessary.
authority. Is there any allegation against you? Then? How are you a necessary party?
But they have filed another petition in the
Suspension method.
that suspension matter. Okay. Anyhow, on that matter, they have filed for document, and regarding this, we have filed FIR against them. So,
Heard counsel for the petition parties, this writ petition
May I
is filed
submit?
by the petitioner. In a challenge to the
File an objection, written objection.
order, speaking order dated 15/9/2025. Where is the order? 15/9? Where is the impugned order?
The writ petition,
Yes,
page number 76.
76.
Right.
Order dated 15/9/2025, issued by the Office of the Director of Higher Education, whereby the petitioner was removed from service from his service in the Uttar Borpeta College with immediate effect. The appeal filed against the removal order, which was rejected, is also rejection of the appellate order. The order by which the appeal was rejected is also under challenge. So the affidavit is filed,
No, no.
not filed.
Records has come, but affidavit they will file also. Last 3 occasions.
Notice in the matter has been issued. Parties are represented. So at this stage, the IA 1414 has been filed by the principal, by the
Church.
in charge principal of the Uttar Borpeta College,
that's it.
huh?
So,
Seeking implement present. So, perusal of the IA does not reflect any grounds as to how the petitioner, applicant, is necessary party and thereby seeks implement in the accompanying petition. So, there are the challenge before the court in the accompanying petition being WPC so and so is only with regard to the order disciplinary proceedings initiated against the writ petitioner, which culminated into the order of removal, impugned order of removal of the writ petitioner, and the subsequent order passed by the appellate authority dismissing the appeal preferred by the writ petition. Stop. There is no specific allegation or personal allegation made against the in charge principal in the writ petition. Stop. The in charge principal is also not the disciplinary authority of the inquiry officer relating to the disciplinary proceedings initiated against it. Consequently, this court does not consider the in charge principal to be a necessary party for being impleaded in the present writ petition, without which effective orders cannot be passed. So accordingly, the IA so and so stands dismissed. Writ petition so and so be listed. After 3 weeks, parties may exchange their pleadings in the meantime.
Hiring this department to time lottery for filing a.
We have already indicated they will exchange pleadings if they want.
Only fix a date lottery.
No fixing a date now. Okay. Yes,
For amending the, they are in the.
amending the prayer. Any objections here?
With other matters of time for filing operation.
Seeking a party, prayer for amendment,
Yes, Lord. But it will change the entire.
you're filing your objections. IA number 1551 of 26 is filed by the applicant writ petitioner seeking the liberty from the court for amendment of the prayer in the writ petition. So, Mr. D. Women is hearing for the opposite party.
4 and 7. 4, 7 and 8. And 8.
4, 7 and 8 submits that the amendment sought for will change the nature of litigation and the issues. Therefore, like to find necessary objections in the IA. Prayer made is allowed, release this matter again after 4 weeks.
That 2 lordship and 25 is similar lordship. So that matter may also be taken up at
24 to 25. They're all connected.
24 and 25 lordship are similar lordship. 24 is fixed at 2. Lordship, this matter 25 can also be taken up at 2.
25.
Yes, item 25.
25 is not called up, 56 is called.
Okay.
Item 56, my lord, we have
Complied.
complied with the order, my lord. Today we are filing the affidavit, my lord.
Order complied.
Is order complied with, my lord? We are directed to file an affidavit to that effect. Today we are filing it, my lord.
Mr. N.J. Katonia, appearing for the respondents, submits that the order has been complied with. Directions contained in the order dated Lorenzo passed in WBC so-and-so, complied with. They are taking steps to file an affidavit, bring the order compliance on record. Submits the matter will be listed next week.
Next week, my lord.
Accordingly, we list this matter again next week.
Obliged.
Matters become important.
Matters became infatuous. It submitted that the writ petition has become infatuous.
Arbitration petition lordship.
Also, the arbitration petition. Why?
Lordship, because on the last occasion, Lordship, a submission was made that they had approached the Honorable Supreme Court. And thereafter, the Supreme Court had dismissed their SLP, Lordship. Lordship wants to go to that order, Lordship.
Yes. This petition under 11.6 was filed by the petition for appointment. The arbitrator was appointed on a petition filed with the respondent.
Yes, sir, Lordship. Had filed before the Telangana.
However, the respondent had filed a similar petition before the Telangana High Court, by which Telangana High Court, by order stated 24/26 and 27/26, had referred the dispute to arbitration. So this order was assailed by the petitioner before the apex court in SLP number 19870 and 19871 of 2026. The SLP came to be dismissed by the order dated 15/6/2026. Same order is extracted below. Considering the fact that the apex court had appealed the appointment of the arbitrator by the Telangana High Court in petition filed before the Telangana High Court by the respondent, and the arbitrator practice same stands dismissed.
Wait, people. All of you, in this matter, on last three occasions, my learned friend appearing for the respondents had wait for some time to file the objection for that. However,
Are you interested to file objections? or
Yes,
not?
Lordship, we are filing it today itself, Lordship.
Mr. Yu Bush, counsel for the respondent, submits that he filed the objections are being filed today during the course of the day. Such submissions, the matter stands deferred to be listed after 2 weeks, enabling Mr. H. Mahan to take the required instructions on such objections that is stated proposed to be filed by the respondents. Relist this matter again after 2 weeks.
we can pay for any convenience. Highly obliged.
Much obliged.
this case, respondent number 4 filed a affidavit in opposition. We filed a reply with the.
You filed it.
No, I have not. There.
Counsel for petitioner, praying for 2 weeks time to file rejoinder affidavit. The affidavit filed by the respondent. Release this matter again after. Thus it appears that the respondent.
Who is appealing at the CGSA lawsuit.
Hmm?
This case, for respondent CGSA lawsuit, A. Gogoi is appealing lawsuit. For timing or any other day.
Just a matter of appointment of the arbitrators.
That's right. We want to know whether they want to file any objections or not. Who's for the, there must be some other CGC. Are you a CGC?
No. On behalf of A. Gogoi lawsuit. For timing, I will.
Just order task.
He's here in court.
Yes.
Timing.
Extra copy as well as soft copy and we present them.
Yes.
But we seek some more time for it.
What is the meaning? Don't be so vague. Give us what time you want. This is only for appointment of an arbitrator.
Yes, no.
Any short 2 weeks.
2 weeks further time is prayed for by Mr.
Sure.
S. Sharma appearing for the respondents. File their objections. Mr.
Zaman.
M.M. Zaman
Lord.
appears for the petitioner. Release this matter immediately after 2 weeks.
Hello, 32, 33, 31, 32, 33.
31, 32, 33 of these matters. After 2 weeks.
Lord.
Same respondent.
Lord.
Yes.
File the reply, madam. Reply has to that we filed by
You have filed your reply.
No, I have filed it, so they have to file the response, madam.
Who's for the respondent?
Yes, yes, madam.
Heard Mr. B. Purukashta, counsel petitioner. None represents the respondents. Matter be posted for admission. 26th of August.
DK Roy was hearing, but due to her difficulty, he is unable to come here.
A prayer is made on behalf of Mr. D.K. Roy, counsel for respondent number 2, that is the legal hearing. Inundation. Accordingly, is this matter next week?
There is an interim order.
Interim order, Delhi will continue. Yes.
Non-payment of
As per my instruction that the pension proposal of the petitioner has already been furnished to the director pension lawsuit.
Director of Pension.
Lordship.
So Director of Pension. Represents Director of Pension.
Government.
Yes, government advocate, who's there? Who's the government advocate here? Huh? After some time. All right, after some time.
I'm sorry, Lordship. In item number 35, Lordship, it is honors as non-appeared presses.
None appeared.
Yes, Lordship. Lordship, in this matter, Lordship, my affidavit has been sent for vetting now. I'm just waiting for.
We are fixing it, I think, next week or some day. 26 August.
Lordship. And Lord, within 2 days, we will file our affidavit. And in the meantime, Lordship, several similar matters will be fixed, Lordship, on 7 of August. Lordship. Similar matters, Lordship. Kindly take.
But you have
Taken
not
up.
filed. You have to file your affidavit. They may
Affidavit
like to
will
file
file.
their reply
Within 2 days, Lordship.
within 2 days.
Yes, Lordship. Already prepared, Lordship.
File it within 1 day. No,
Yes.
2 days.
Send for.
It is submitted by Mr. B.C. Mujari, Learned Counsel, appearing to the PTC authority that within 2 days he file the affidavit. We have to respond.
Matter may be taken up.
He submits that there are similar matters which are fixed on 7th of August.
7th of August.
He submits that
WPC
these
number
matters
three.
be listed along with WPC number
3846 1025.
384625 and other connected matters. In the event the affidavit is filed, petitioner is permitted to file rejoinder, if so it writes. MSRB Bora for
Respondent number 6.
respondent number 6.
NI.
Mr. Alam for respondent number 5.
Masu.
Just filed my affidavit in opposition in the matter today.
Today.
Just, it's not on record.
Next week, we did.
Don't want any reply,
Lordship.
not necessarily. MS RS Chaudhary, Learned Counsel, representing
Respondent number 2 and 3, Your Lordship.
respondent
KVS.
submits that the affidavit has been filed today. Okay, counsel, where counsel, Mr. Goswami, counsel for the petitioner submits that the matter will be listed next week. Accordingly,
29.
can be next week. First week of August.
This is the case, Lordship, the small children, one admission in JNB school. And he was selected ultimately because of some anomalies, he was not given it.
Right, 29th
29.
of July.
Lordship.
The registry will trace out the affidavit stated to be filed on behalf of respondent with me and connected to the case record. Yes, I, R doctor for respondent. Respondent number 1.
Apply.
Implement.
But our submissions were already made the last date. Only one aspect the government wanted to highlight regarding the discrepancy in the PhD certificate of the petition. And that apart, one fact I may submit before your lordship.
No, they are praying for some time. Whatever you want to submit before the president of the council. After some time. And then let us have it at 2 p.m. 2 p.m.
I have some difficulty with that. Well, I'll try to be here.
filed
Lordship, we need 2 weeks time to file it, Lordship. Actually, we are ready with it. We have sent our communication to the respondent number 6, Lordship.
Have you seen the counsel for respondent 6 submits? Renew the prayer for filing affidavit. Praise for the time. Counsel for petitioner does not make prayer made.
as Sharma on behalf of
Or
Accountant General.
let us know if you- Or 5. Released immediately after 2 weeks.
I'm obliged, Lordship.
In this matter, we have filed one IA, my lord, to allow us to file the affidavit in opposition. In the meantime, we have filed our affidavit in opposition in 17/7/2026.
Yes, delay,
2
my
days delay, my lord. So I have filed mine.
Affidavit in opposition.
Yes. Actually, Honorable Court has directed us to file the affidavit in opposition on 15/7/2026. But we have filed our affidavit in opposition in 17/7/2026. 2 days delay is there, my lord, and so we have filed one IA for that.
Alright, Mr. U Sharma, counsel appears in the IA number F of the applicant is 368 of 26. Submitted that as per the order passed on 19/6/2026 in the accompanying petition. Liberty was granted to the respondent by their
No
affidavit.
objection, madam. IA. What is IA? We have to. Yes, delay. What is IA bylaw? Don't have any objection. 2 days delay.
That's right. So by the by order passed in the accompanying writ petition dated 19/6/26, the respondents were permitted time to file their counter affidavit within 18/7/2026. So the respondents had filed it on 17/7/2026. Therefore, this present IA has been filed seeking liberty to condone and extend the time beyond 15/7/2026 and accept the affidavit filed by the respondent of report. The counsel for the petitioner does not object to prayer made. So by the order dated 19/6/2026, affidavit was directed to be filed on 15/7/2026. The respondents have filed their affidavit on 17/7/2026. Considering these 2 days of delay filing the affidavit, considers it appropriate to note that same delay and the affidavit filed by the respondent will be taken on record by the registry. IA accordingly stands allowed disposed of. The petitioners are permitted to file their rejoinders within a further period of 3 weeks. Release this matter after 2 weeks. The registry will connect the affidavit stated to be filed by the petitioner.
In this case, I'm leading by learned senior counsel Mr. Prithesh Hoyte, Lord. Now he's in another court, Lordship. Can I pray that maybe fixed on 6/8, Lordship?
Fixed on
6/8, Lordship.
on the request made by the counsel for the petitioner, matter stands referred to be listed on 6/8.
Lordship.
Pleadings are exchanged.
Lordship.
6/8.
In this matter, the declaration from the arbitrator appointed for our side was forthcoming. It has already come. Continue. Declaration in original is there.
submit to the registry, let them bring it on record properly.
Actually, I think it should have gone to the registry itself directly, but
Oh.
it was given to me, so I thought I will furnish it before last today.
They said before the
I'll fetch it
registry,
before the
let them-
registry.
let it come properly. It is submitted that the written declaration required under the occupation. Have to do. Chief Justice of the Manipur High Court. Permitted to submit it to the registry. The registry will drop the papers to the court record and place it before the court. Friday?
Yes, sir.
Friday.
All right.
Or let us do it like this. 29th, sometime on 29th of July.
I will furnish it during the course of the day only.
Much.
Now, the matter relates to provincialization of those leftover madrasa teachers. And they have not been provincialized. My lord knows that by virtue of Appealing Act, madrasas is now no more schools. They have been converted into schools. And these institutions wherein the practitioners are working, admittedly they were not provincialized. Now the state is saying, that there is no institute is operating for the purpose of provincialization of the Madrasa Institute. Our case, we have projected a petition that, as this institution has already been transformed into high schools or the similar category. So therefore, under the 2017 Act, we cover. So now they have said that, that we cannot become under the provision of this 2017 Act. That issue is, my lord can decide whether we are entitled under this 2017 Act or not.
Madam, in this matter, we have not filed our activity in my lord, so sometime will be granted.
Respondent,
Respondent number 2.
you filed it.
Yes.
Director, secondary
Directly
education,
fine.
you filed it. For once you have filed it. Want to file rejoinders?
Now, this is a question of law, which they have raised.
We'll issue, we'll
My lord, can
hear the matter.
yes, on any day. Some urgency is there, because
Some urgency is there.
no, some of the members of this petitioner organization now going to be retired jobless. Similar person has
Submitted that the pleadings are complete,
Fine.
matter be listed on 26th of August, sorry, 25th of August
Mal.
for admission.
Obliged.
Last order passed by the, Lordship will see the order dated 17/6/26, my lord. Lordship, the Talukdar is appearing, my lord. Can this matter be taken up sometime, my lord? Mr. Talukdar is on legs on the different court, my
It's not a ground for adjournment.
lord. Some record was supposed to be produced, my lord. So therefore, he's up.
That says that he has to be some at 10:30.
Lord, I am actually not appearing, my lord. Lordship will see the order, my lord.
It says,
So my lord will have it after some time, my lord. We'll inform him. The leg section.
so this order is very clear, there is direction to the council to make a mention at 10:30 a.m.
No, must be knowing, my lord. I'll inform him now, my lord. But after some time,
Whether the records are there or not,
not inquire hearing. After some time,
what after some time? When there is a judicial order that the matter is to be taken up at 10:30, you don't have the liberty to defer the matter being called on board.
I have to. But I have appearing, but
Where you are appearing, but please inform him what
I
is
inform
this.
him.
Call him now,
Well,
wherever he is, or you call your senior standing counsel, who's there.
Mr. Talukdar is there.
So you said he is not available, please call the senior standing counsel or whoever is in,
He's coming.
who's apprised of this matter.
But he's there. He
We'll
comes.
call up after 10 minutes, or we are passing orders.
Well,
This the restaurant number 5 has filed their affidavit, but the other restaurants have not filed their affidavit till now.
Who are the other respondents?
President of the GV.
What is the grievance here?
The petitioner are paid for furnishing service book for inquiry. Copy of service book, but that was not provided to him. That is the
Service book?
Copy of service book he required.
Why?
Proceed, there was some wrong entry. I made statement in the petition. What was the wrong? Because there is some order that we give of the petitioner as withheld, but instead of that,
You can't get a service book, mayor. What the mayor asking?
That will be as per the confidential rule 1990. Everything will be as per that.
they have filed their affidavit. And state also. So I can file my counter affidavit also.
Mr. Raj Sharma submits that you'd like to file the counter affidavit. We have filed. How much time you want? Praise for 2 weeks' time. Stuff.
By this time, the other respondent, the president, is not service is completed and service maybe because he is an activity then but there is a legal issue. That is the
Sorry, I get you.
but the GV president is not being served. So if it is not served, then direction may be issued to face the school nurses. Because otherwise he will
Service
not come
not complete.
verbally.
What's it?
Verbally.
Respondent 5 is represented by counsel.
Yes, I am
Respondent 4.
There is an order of dusty, but in the meantime, the petitioner came to know that there was some meeting in this regard, therefore the notice was not affected. So I shall serve the notice that dusty I have taken from the registry.
Petitioner is also permitted to serve notice by way of dusty as permitted earlier by the court on respondent number 4. Affidavit of compliance be filed the matter. Release taken after 4 weeks. Or 2 weeks as you say, 4 weeks.
Awesome.
Yes, Mr. Gurmai,
In this case, matter come for second time, we are waiting for instruction also. After issuing notice for the first time, it is come. After 2 weeks or 3 weeks.
Mr. K. Gurmai is in the CDC submits that permitted further time to complete instruction. Please for 3 weeks time.
What is it? 2020 has been pending.
2023 claim, they have filed the arbitration
And
petition
the
on
last time
26 lawsuit.
The last time when it was listed on me, they were given a right to file their objection.
Counsel.
But you were carrying a list of arbitrators from the department itself. If they are agreed to it, they
All right, 2 weeks, get it within 2 weeks. Released after 2 weeks. Mr.
E. Sharma. E. Sharma.
E. Sharma appears for the petition. After 2 weeks.
In this case, Mr. Brijesh Sharma is appearing lordship. His daughter has been hospitalized.
For what purpose?
Regarding non-payment of
Non-payment of
He's appearing for the accountant general.
Yes.
So you have furnished everything to accountant general.
But one letter, Lordship, is 24th of February said we have not received. After that clarification whether it has been received or not, that is not.
Sixteen 5/26, there is a communication on record that it has been forwarded to the accountant general.
Lordship will take instruction whether that have, all the papers has been received or not.
The Council for the Elementary Education submits that the proposal is of area family pension has been furnished to the office of the accountant general. So Council for Accountant General submits that they would like to complete their instruction on the matter. Praise for
He will be appearing on behalf of Vision.
praise for how much time? 2 weeks. Next time. Accordingly, matter will be listed immediately after. 5th of August.
In this case, I am appearing for respondent number 1 and 2. Earlier, I have taken time to file lots of affidavit. I could not file lots of another 3 weeks time maybe granted.
MSR Devi appears on behalf of respondent number 1 and 2. What is 1 and 2?
That's it.
1 and 2.
1 and 2.
She prays for further 3 weeks time to file, complete her instructions and file affidavit. Mr. Any objection? Counsel for the petition. There may release this matter again.
Obliged.
In this matter, 3 weeks may be granted to file our.
Only to decide whether the matter stands covered by order dated 23/5.
My lord, regarding that, my lord, our file has, my lord, sorry to say, my lord, it is misplaced, my lord. So, my lord, I cannot.
Where is the order dated 23/5?
Lord, it is the last page.
You take help of the second file of the court.
Yes, there is second.
It is with my learned friend. my lord.
Yes, yes,
You take
It is
help
of
and find
discussion.
out.
yes.
Only thing is to apprise the court whether this particular order of the court at page number 47 begins at 47.
Yes.
The order is at page number 51, dated 23/5/25, covers the issues raised in the matter.
In the second half, my lord.
Second half.
Yes.
Very well. Second half.
Well, Lord, in item number 58, we have
Somebody has prayed for some time.
date.
After 3 weeks.
Can be in the
2 weeks. All right, 2 weeks.
all right.
Today for disposal of the matter, my lord, two similar repetition was disposed of. Same was in take with this record, my lord. Only my lord, pair my lord is that they are all are appointed as a accommodated as a tutor, and for modification of the tutor and respondent, my lord, director, my lord, petition. I had ordered annexer 9, page 130. Annexer 9, page 30. It is the verification of private teachers and so with reference to this, I have to like to enclose copies
copies of the DLF examination marks is required for organizing as well following candidate request to conduct back copies of the verification set for application minor as a tutor to minor assistant teacher. Page 130 and 131 minor. And there is under consider a similar pair minor your lordship dispose of in minor track with this minor. All records also take the meta. Give a copy to the other side. You examine and tell us.
Lordship, and one more thing, my lord, what my instructions are is that, my lord, there is a similar coordinate bench judgment also, we also have, my lord, which has basically dismissed the case, my lord, of tutors, my lord. I would like to produce it before your lordship.
Yes.
Paragraph
We are
15.
You exchange the order,
So-
we'll take it up again on.
Yes, your lordship.
22nd.
This is the one which I have, my lord, of Sivsagar district.
But I
I'll
told
be-
that is not correct. I am
I'll show-
from the.
Have you seen it? You've seen that order.
That is different order, madam. That is in.
What about this order? Have you seen this order?
That I have not seen. I'll go through it.
I'll go through it.
I'll go.
Go through it, come back at in the second half if you can. Or some other date,
Some other day, man.
day after.
Fine.
22nd.
22nd. Deeply.
His name may be.
My name is.
Mr. N. Bora, appears for the petitioner, Mr. A. Fugan for the respondent, so and request to release this matter again on 22nd. Respondent, the counsel before the court, they apprise the court whether the matter stands covered by the order dated 19/12/25, passed in WPC 3185 of 24.
No, take it up 25.
Not 23rd.
I think something.
All right, then let it come on 29th. 29th.
My.
29th.
Deeply. I know he's on his way, my lord. He's here only, my lord. He was on Lex in a different court, my lord. He's just coming. He just informed me.
Come to the
Just after,
Rajan Gamma.
At 2
We'll take it up at 2 p.m.
p.m. Deeply afraid.
What did
IA has been filed seeking an interim direction for the students of homeopathic medicine to appear in their final year examinations. In the main requisition, this was issued and my learned friend was directed to obtain instructions. In the meanwhile, the exam has been notified, which is to start from 27th of this month. Now, I'm simply seeking a direction to allow me to appear, and my results will be made subject to outcome. And in the connected item 25, that protection has already been extended to the petitioner.
Also, will see the order dated in the main writ petition, that order dated 25/6/2026. WBC 3414/2020.
The operative portion is the very last parameter. It's provided that in the meanwhile, if the notices for examination is so issued, the petitioner is found to have fulfilled all the requisite criteria mandated for appearing in the examination. Petitioner shall be prompted to submit his application for the said examination and to appear in the exam. However, results of the petitioner shall be kept with it until further order. So this seeking a simple direction.
Well, one order is already there in the connected case, so that may be passed in the IA.
Item 24.
Third. Second. IA number 95. What
Students of final year,
BSMS,
final year, the Bachelor of Homeopathic Medical Science.
science.
Regular exam. 27th.
27th.
7th of July.
yes,
For the fourth semester.
And why are they not permitted?
no reason has been given till date.
Well, the reason is that, well, while completing the first semester and the second semester, there should be a gap of 6 months between the two semesters. That is missing here by a few weeks, man. I got the instruction.
Similar definition. WPC 1. By very 626. Petitioner therein was permitted to submit his application to state examination and to appear in the state examination. Subject to the petitioner fulfilling all requisite eligible criteria mandated for appearing in the state examination. However, the results 6 months is also a mandatory provision.
There
Yes,
is a
well,
mandatory report.
But that
In
requires
terms of
final
this
year.
order, you don't fulfill, you are not allowed to appear.
That is the issue which I have impugned in the requisition,
I don't know, we are saying that the order which you are referring to says you will satisfy all requisite eligible criteria.
Then, my lord, that particular relaxation clause which is there in the guidelines, my lord, that may be brought in and I should be allowed to sit, my lord.
Now, in the next case, the Homeopathy Council has already filed the affidavit. This is the main ground, my lord, where they are objecting. But we have communicated with them.
That issue requires hearing.
First. Homeopathy Council has filed their affidavit. In which matter? Both the matters.
In item 24.
24.
3035.
Yes, ma'am.
3412, 3025.
3025.
Okay. Right? Gap of 6 months between
Two semesters.
two semesters.
But the ground is same, my lord, that may be recorded. I have got the
Submits that instruction also. Right there.
My lord, in the main repetition, Lordship, can we come to page 87, my lord? 87.
Did you file any application seeking relaxation?
My lord, the state is concerned, my lord, they have already, state has moved.
Huh?
The state has moved, my lord, the Homeopathy Council for relaxation, my lord. That has not been allowed.
That has been rejected.
My lord, what I'm saying is the issue which I have impugned in this instant repetition is regarding the relaxation clause. For acts which the university has carried out, the gap which it's their fault that there's a gap between the examinations held. Now I am being a student, I am being prosecuted. Now at least let me appear till date, till my learned friend has submitted that so and so is the reason. No written reason has been given to me, no order passed. And if I am to complete that gap period, my lord, I am to appear in those classes. Have they said till date that okay, go and conduct the classes? That also they don't say.
See, the reasons have already been given by the Homeopathy Council.
Yes. Yeah, no, they have only said so in their affidavit, ma'am. There is
Whatever
no
it
particular order as such. 14.3, ma'am.
Relax. The students are not at fault.
They in conducting the
So they
examination.
delay in conducting the examination, which resulted. Yep. 6 months. However. Don't think the confirmation. Semester of the EAMS,
Fourth year examination.
PHMS,
PHMS.
Fourth?
Fourth year examinations.
year exam. And that of the same shall not be declared without leaving the court.
My lord, add only one, my lord, they may be allowed to submit their application form also.
For the purposes of permitting the necessary application form, a shall be accepted by the court. In terms of the passport, permitting them to appear, in terms of passport.
I knew. My lord.
For which respondent? Either for
Need only 3 and 4. Item number.
My lord, that quotation. Item number 3412. In my order, my lordship, when the first it was listed on motion, my lordship, the respondent only raised the question of attendance, my lordship. They allowed the,
You are appearing in which writ petition?
my lordship, writ petition 3412.
Yes, ma'am. The other amendment, next one, 25.
25 is one year.
Kindly see the interim order, my lordship, which the honorable court has granted, my lord. The followed authorities, my lordship, now they are saying that I have raised what I have raised in the writ petition, my lordship, the 6 months gap, my lordship. When the
No, you have the interim order.
my lordship,
Ah.
the interim order, it is stated that if I fulfill all the criteria, my lordship, at that point of time, my lordship, the contention of that 6 months gap, my lordship, it was not raised by the state, my lordship.
We have already it is already directed that you shall be permitted to appear. What is the
Only
problem?
that part is not.
If any modification is required, you have to file an IM and.
Not one minute, at that point of time, my lordship, the
There
respondent
is an
did not,
order saying that permitted to appear something. And so,
all conditions, my
Conditions.
lordship.
is there any restraint?
My lordship, no restraint, my lordship. Then
Is there
Yes.
any restraint?
College
May-
is the college authorities are saying that
may
I
saying
don't
will
full,
not do, you bring it on record, why we not brought it on record by filing the what is the meaning of college authorities are saying? The college authority saying it without getting clarification from the interim, from this court?
my lordship, I have not allowed to submit my application.
Bring it on record. Why have we not brought it on record? Why have we not filed an application saying that in spite of the interim order, you're not allowed to file? This is what college authorities are saying. This is the order passed by the court.
File your application.
Yes.
In this case, my lord, the similar case
You
is
said that there is similar matter.
Yes.
Item number?
Item number is listed today. The WBC 2737/2025.
What is the order passed there?
But the issue is that, my lord, the NOC has been, the
What
petitioners,
order is passed there?
they are fixed on 30th for,
Right, let this matter be listed again on 30th. Along with WPC
2737/2025.
7370
2025.
25. Mr. U. Sharma, accused.
And in those cases, notice is issued, my lord, it's for admission.
Give us a copy of the order. You said the similar order. Give us a copy of the pass order.
In this case, my lord, the petitioners are, my lord, the applicants for the post of principal for the of the higher secondary school, my lord, and they have submitted their representations, my lord, for condonation of their age. It's, they have crossed the 57 years of age, my lord, and they have submitted representations, and director second
Somewhere it is rejected.
not rejected,
In terms of some judgment or some
not
Negated.
rejected. No, I have annexed judgment, my lord, as an example.
example for what?
Example, in such cases, my lord, the relaxations, representation, directions will issue for disposal of the representation.
Court had passed some order.
Yes, your lordship has decided one issue. I have appeared, my lord, WBC 2533/2026.
Where
It
is
was
that order?
it was in respect of the Dima Hasa, and this is in
Where is the order?
that order is not annexed before that is filed.
Get a copy of that order. Let us collection. Dispose of.
Yes,
Give the number, let the state also.
2533/2026.
This matter be listed again on Friday,
Friday or Wednesday or Friday?
Wednesday, 29. Good evening, Mr. Pastor. Please give an order passed by this court.
2533/2026.
53326. State is supposed to give something.
My lord, one order they wanted to produce, which I had already shown to your lordship at page 315 of the affidavit in opposition. And alongside that, Lord, the another fact that your lordship may take into account. After this order at page 315 was passed, petitioner had filed 3 writ petitions. There was the selection procedure, there was a selection process, and by filing 3 writ petitions, my lord, he had
315, what is
315, my lord, is the order by which, my lord, the honorable court allowed us to proceed ahead with the selection for the post of principal, regular principal.
Now, after we had undertaken that exercise, he had there the post of a person was selected for the post of principal, and the writ petitioner had filed 3 writ petitions challenging the selection process, the selection of the private respondent therein, and also seeking his selection in the matter. But ultimately, he withdrew all these 3 writ petitions. So basically, my lord, it was a foregone conclusion for him that he would be in any case pursuing his selection for the post of principal. These are the 3 writ petitions he had filed, and ultimately he had withdrawn all, leaving the challenge to the challenge to the selection to the post of principal. Possibly, my lord, Mr. Gogoi wanted to bring this.
Why was this writ petition filed? This particular writ petition?
This writ petition was filed seeking his consideration for the post of principal. But for the intervening circumstances that I submitted on the other day, my lord, the secretary had given a determination that his case cannot be considered for the post of principal. Now, thereafter, the matter was lingering because there was one order from this honorable court saying that he should not be allowed to hold the post of principal. So he was pursuing his remedy here. In between, a situation came where the college was having the need of a regular principal. So we filed a IA, my lord, seeking the leave of the honorable court to go ahead with the selection. Page 315 is the order passed by this honorable. Now, thereafter, the selection process was undertaken. And by filing these 3 writ petitions with the orders of which, my lord, I have placed before your lordship now, he wanted a determination against the process of selection and eventual selection of the principal.
That was withdrawn.
But that was withdrawn. So now, in view of the
selection process is complete.
That was complete. A regular incumbent came and he subsequently retired on attaining the age of superannuation. At present, my lord, the post is being held by one gentleman on in-charge basis, since there is no regular principal. So, probably, my lord, that is the circumstance which impels him to again resurrect the process in this writ petition so that he can somehow get into the post. But the reason are basically 2, my lord. First of all, is
your candidate which was selected or pursuant to the selection process which was undertaken had left the college for superannuation.
Yes. One left the college and one superannuated.
Now it is presently being held by a person
on in-charge basis. Yes.
Now for making for it up on a regular basis, you have to follow the proceedings by issuing advertisement.
Yes,
Has
exactly.
the process been undertaken?
No, it is not undertaken as of now, but the process has been initiated. That is my instruction.
So, assuming the petitioner is still in service?
He is still in service.
Still in service as an assistant professor or something?
Assistant professor in history.
So, it's the feeder category.
Not feeder category as such, but because
eligible.
No, he is not eligible because he doesn't possess the PhD degree.
Otherwise, assuming he has a valid PhD,
then he can compete in the selection process. But there is a determination by the departmental secretary, my lord, which comes on his way, and for which, my lord, he had to file the writ petition. My lord, that your lordship will see. Basically, that is the order which he has challenged, page 109.
That he was provincialized as an assistant professor.
Yes.
Therefore, he cannot be.
He cannot. Yes. But that
pursuant to that, you had proceeded for regular selection.
Yes.
Or is it after that?
No. Yeah. After this one, after this order, my lord, we had proceeded with regular selection because 315, page 315 order, your lordship will see.
Where is the impugned order?
Impugned order in the writ petition is page 109. And page 315 order was passed on 28th of August 2017. That is after this determination came.
And in this writ petition, there is no stay for initiating the process.
In fact, my lord, there were other writ petitions pending by same writ petitioner, and therefore we sought leave of the honorable court to fill up the post by holding a regular selection.
Yes, madam. That was the submission you made earlier. Then your senior was hearing. Attempt to make a mention that this matter should be taken hold of now. It is expected that he is aware that the court has taken the matter at 2 p.m. These are instances where you have to address the court. So bring and address the court. That I bring is with you. Your senior must have asked you to address the court.
For that lordship, so this in the in between lordship, petitioner has approached before his honorable court lordship, whereby he is challenging the lordship the validity of the PhD degree lordship which has issued. I asked and claiming also principal also. In that
The issue where the present petition the
lordship,
that realization
so regarding assistant professor, no issue lordship, he is assistant professor. His claim is regarding lordship principal lordship.
that's right. The issue whether the order at page 109 is correct or incorrect. That is the only issue to be
Lordship,
determined.
109 is the lordship correct and valid order lordship. But last occasion when matter was called up lordship, we have placed before your lordship that the PhD degree was obtained by the petitioner is a forged lordship.
If that be so,
Lordship.
now for the post of assistant professor, whether PhD is required.
Yeah, in respect of assistant professor, PhD is required lordship, PhD or net slate. PhD or net slate.
So if that is your argument, then you will have to take action against him. Then the post of assistant professor.
So lordship will do. Before that lordship, just last occasion my lordship wants to know lordship whether his PhD degree was genuine or not lordship. In particular aspect lordship, aspect petitioner preferred a writ petition lordship 264 of 2021 lordship. In that particular case, my lordship directed the UGC to lordship cause an inquiry lordship regarding whether that particular PhD obtained by
Mr. Gugoi,
lordship.
what other writ petition with regard to what other subjects are not connected here? This writ petition issued on 3rd of September saying that realization has to be relating to assistant professor and not principal.
Lordship.
Is correct or incorrect? That
But
is the
it's a-
only issue. There the question of valid PhD doesn't arise.
It's a correct. His claim is lordship. Otherwise, also principal claim.
That is your submission that is
Lordship.
correct because you have to defend this order.
Lordship.
But the court only has to see whether this order is correct or wrong.
Lordship.
Is PhD being valid or invalid? It's irrelevant here because PhD is invalid. according to you. Then his provincialization to the post of assistant professor will also have.
Assistant professor will also go lordship. He will become a tutor lordship. He will become a tutor lordship.
But that order is not reflected here.
It is not reflected. Otherwise, lordship. His pair is lordship. Page 28 lordship. Page 28 lordship. Page 27 onwards lordship. His basic pair is to provincialize the service of a principal of the broadcasting lordship. In all along all the pairs lordship, same pair he has lordship made regarding principal lordship. Pair number B also lordship.
So therefore, in that context, please for setting aside this order.
Because in that particular context, he is not entitled for the principal post, as because the required qualification for the principal to be lordship PhD is one of the essential requirement lordship. Along with lordship in that particular post, he should.
What we are trying to understand. Is required only for principal or is it also necessary? For
It is also necessary for the lordship assistant
So it
professor,
is
either PhD or
necessary.
net and slate lordship.
Very good.
Lordship.
Then
Lordship.
this argument will also apply post of assistant
Assistant
professor, but we
professor
have not taken any steps towards it as on date.
Yes, because we multiple, not only this lordship, The petition, almost 20 writ petition is pending either this way, that way also.
Therefore, we are saying that let us attempt to complete one writ petition after the other.
Lordship, lordship,
Right.
Right.
So this writ petition, the question is disordered, the correctness of this.
lordship. For that purpose, that particular report is very much necessary. lordship.
But
That UGC's report. lordship.
so that would not reflected here.
Here not
See,
reflected,
see,
lordship, regarding is
the only question here is the specialization in the post of professor, no, post of principal not being done,
Yes.
not on account of lack of qualification. It is on the ground that he was
Yes.
found to be provincialized as an assistant professor prior to the
cut-off date.
cutoff.
Cut-off date.
That's the only issue.
That is the only the issue, lordship. And that the particular subsequent event is that it is on file in 14 lordship. After that, another so many orders was passed by
That
the authority.
subsequent event will come only when we propose to hold that this order is incorrect.
Lordship. Now, I will address it. Otherwise, lordship, I will address all the writ petitions are connected. He filed a writ petition from 2009 onwards.
Why
lordship.
should we involve matters when the issue here is very simple? We have to page 109.
We'll
Only
place it, lordship. Once for determination of 109, lordship. The law is very clear, and even the
place the law and
lordship,
even in judgment or whatever you want.
lordship,
Here it-
lordship. Even regarding just clarification out of that part, lordship, my lord may kindly peruse for a moment the report of the agency, lordship, which was
Why are you
lordship,
forcing us to peruse something
Yeah,
which is
Lord,
not
Lord,
necessary for the
Lord,
purpose?
lordship.
As and when that writ petition comes, we will examine it.
That writ petition they have withdrawn after coming of the report. lordship. That writ petition was related. That writ petition was in once occasion it was taken with this particular petition. lordship.
Okay,
Lordship.
that is correct. Then the matter will have to go back to the authority
Lordship.
to redetermine
Lordship.
claim they are to provincialize. Therefore, it is only that event. Then the other questions of his eligibility will also have to.
Lordship, I have no difficulty. I am
So as on date, we have not made up our mind to either allow
Lordship. Lordship.
rejection.
Lord, I got.
Trying to understand this order.
I got.
Or is there any other order that is being challenged?
Lordship, I got.
Whereas this petition prayer is specific, that this order,
Order should
Has
go
to be
and he
given.
should be lordship
he should be.
as
given
a
the
principal. Lordship. I got.
And this order, not, its claim for provincialization as a principle is not rejected on the lack of eligibility.
Lordship.
So the
Right.
question of the period of service which is rendered, and he was found to be that list prior to the cutoff date in the post of assistant professor.
That is the yeah. Just the indicate lordship. Subsequently, so many development was going on lordship. Just the indicate lordship as because where the claim of the petitioner is rejected on the ground of the principal lordship. In some writ petition he have filed lordship where the honorable court directed to reconsider his case. Then we have come up with the lordship certain speaking order. Then it was challenged before his honorable court. Then honorable court directed the UGC to verify and cause an inquiry by constitute a commission lordship. UGC constitute a commission lordship. The commission's finding is that lordship totally false and false document lordship. I will place everything lordship at the time.
When?
If they then I can they also is absent any day lordship.
I may address your lordship. My submission would be, as on date, my lord, the examination of the validity of page 109 has become sort of infructuous because of the subsequent events also taking place, and also for the fact that the petitioner's claim for provincialization of his service is not relevant consideration as on date because he is not in that cadre. He is only in the cadre of his case for provincialization in the post of principal will arise only when he goes into that cadre.
As that has been claimed that he was already there, then in charge.
No, he was there as an in charge, but unless and until
And therefore his provincialization has to be made from respect of that particular.
now in charge holding a post on in charge basis whether it does not confer him any permanent status. It was only a stopgap arrangement. Now, because the authorities found that for this reason or that reason, he was not within the fold of provincialization. Well, that case cannot be considered. As on date, his case for provincialization in the post of principal can come only when he would be in that particular cadre. He is not there. And because of the subsequent events taking place, regular selection to that post has been held. Tomorrow, your lordship may excuse me. Sorry, I will not be here tomorrow and day after.
Mr.
Malo.
Yeah,
Malo.
your only claim is page 109.
Malo. 109. Yes.
But 109, you're holding, at that point in time, you're holding the charge as Mr. in charge.
No. I am holding the post, my lord, as a assistant professor in the Department of History.
Right.
My lord, our case is very limited, my lord. They are saying that as the cutoff date fixed in the my lord statute as before 1/1/2011. So as my cutoff date is 4/6/2011, so therefore I am out of the purview of provincialization. Now, my lord, for the similarly situated adjectively placed principals and other teaching staff in the entire state, given the benefit of the employee, definition of the employee means, my lord, those who are working in a particular college since long, they get merged with their earlier service period with the fresh recruitment and given the
You are
benefit of
appointed
employee.
as principal, regular principal or in charge?
Myself, my lord. No, this recruitment was for regular principal.
Your appointment is on 4/6.
No, my lord. Initially, I was appointed as a my lord, assistant professor in the Department of History. Then, my lord, pursuant to an advertisement, I did participate, my lord, and I got selected the merit position 1. And then I was appointed as a regular principal on 4/6/2011, and immediately I joined on 4/6/2011. Now, my lord, that's why this honorable court directed that the my lord, because my selection and appointment as a principal, my lord, had also been put into challenge before this honorable court by some of the persons who participated and failed. Now, my lord, this honorable court, without interfering with my my lord selection and appointment, has relegated the matter to the Director of Higher Education, asking him to pass an speaking order, my lord, regarding the exact position of the teaching and non-teaching staff who are eligible under the Provincialization Act to be provincialized. And, my lord, till that exercise is carried out, this honorable court directed that as there is an interim order operating, that I should not continue to hold the post, that the honorable court finalized the order and said that, my lord, till the exercise is completed by the director, I should be debarred from, my lord, continuing as a principal. So now, my lord, they have come up. After the original speaking order, this speaking order had been passed, upholding my selection, saying that due to cut-off date, I am not entitled to be provincialized. That is the issue. Now they are saying that, my lord, I am not qualified, my PhD certificate is fake. Those statements had been made last time. That's why, my lord, this honorable court wanted to know regarding my inquiry and other, my lord, what they have done regarding my PhD certificate. Today is fixed for only that reason.
Your PhD is under cloud.
No, my lord, that clearance has been given by the UGC, clearance has been given by the Magad University. My lord, 4 times inquiry has been made regarding my PhD. My lord, I have already collected all those documents, my lord. And if my lordship allows me, I will bring all those on records also by of an additional affidavit. Because, my lord, this has never been questioned in this petition, my lord, my educational qualification. First time on the last hearing, my lord.
What is this, Mr. Goi? Very good.
Last hearing, my lord, he make this submission that there is a
that similarly situated person will give the benefit.
My lord.
What do you have to say regarding
Provincialization.
that similarly situated person will give the principal prior to the after the cutoff date, after the act being enforced, they will inform under the act and given the benefit. Where are the cases of the other similar person?
My lord, I have brought my lordship's notice on last occasion also, my lord. I have annexed, my lord, in page number 140, my lord. 140, my lord.
140.
My lord. If my lord may be pleased to find Dr. Donamoni Bora, she had been provincialized, my lord, in Samaguri College, my lord. My lord, may kindly note her date of joining 3/8/1992. Kindly note this date. This date of joining is an assistant professor in the same college. And now, if my lord, in this college, Samaguri College, somebody was holding the post till my lord 30th of October 2012 in page 141. This certificate reveals, my lord. This has not at all been denied by the higher education by filing an affidavit till date. My lord. This document says, my lord, this is to certify that.
Where is 141?
Page 141A I am referring. Next page. This is to certify that Pradeep Kumar Kolita had been serving as an assistant professor in the Department of Assamese since 1991 to 2001 and as a principal in charge since 2001 to 30th of October 2012 at Samaguri College, Nagaon, Assam. My lord, may kindly note this date, 30th of October 2012. Now, this for the same college, this Lunamuni Bora had been provincialized on 20th of January 2014. Meaning there, my lord, she had been, my lord, promoted or, my lord, appointed as a regular principal after 2012.
That will be by way of a regular selection.
That's the same case with me, my lord. By way of a regular selection, I had been, my lord.
Your selection was held by the governing body.
Exactly, my lord. And their selection is also held by governing body because this is also a.
Say that.
No, my lord. This is also a same college, provincialized under the same act. My lordship knows, my lord, that under this act, many colleges and schools had been provincialized. This Samaguri college had also been provincialized under the same statute. The employees, which has been referred in this page 140, my lord, is under the 2000. My lord, may kindly note, this is the reference, my lord. In exercise of the authority conferred under provision, I am reading at page 140, of the Assam Bhansar Educational Institution Provincialization of Services Act 2011 as amended, and in pursuance of the government sanction order number dated so and so, the services of the following employees of Samaguri College, Samaguri, District Nagaon, have been provincialized and they become the employee of the state government with effect from 1/1/2013.
Then, any other?
Yes, my lord. Then again, my lord, if we go by this, my lord, at page 143, this Lakhinandan Nath, my lord, may be kindly note this date of joining as 1/10/2001 as a principal had been shown. Actually, he is also not been principal, my lord. If we go by this provision at my lord, page 145, Koina Mahavidyalaya, my lord, this. My lord, many instances are also there. This Koina Mahavidyalaya, my lord, may kindly note date of joining at page 145, 17/4/1993 as lecturer, 31/1/2005 as principal. So, my lord, that means this incumbent has original date of appointment has been kept intact as 1993 and appointed as principal. No doubt, my lord, in this case, it is within the cut-off date, And then again, my lord, this Rinamoni Bordoloi, Koina Mahavidyalaya, my lord, has been, my lord, provincialized at date of joining has been shown as 17/4/1993. That means, my lord, the date of principal has not been given. My lord, at page 147, I am referring.
That you have already shown here.
Yes.
145.
My lord.
That she was appointed the principal on 13/5.
Exactly, my lord.
Right. So this is prior to the cut-off date.
Prior to the cut-off date, but my lord, in the provincialization order, which I am referring at page 147, my lord, the date of joining as a principal had been shown not as a 2005, but in fact it has been shown as a 17/4/1993. That means the original Milord, date of appointment or the past service benefit has not been wiped out, Milord. Because it is within the same college.
That has also not been wiped out in your case.
No, Milord,
because
my
your
case,
assistant
it had been.
professor service is already there.
No, Milord, in my case, what logic they are bringing in the speaking order, Milord, is saying that as I am out of the cutoff date of 1/1/2011, so therefore my selection and appointment as a principal is not valid and it has no force in the eye of the law. But in others cases, Milord, it is the different. Their stand is different, Milord.
From here, it is not possible to.
That's why, Milord, it is our averment and our assertion and it is our record.
See, your case, your appointment was post cutoff date.
That
These
is admitted.
examples that you're giving are
My-
pre-cutoff date.
Oh, no, Milord,
The question of whether their earlier services are retained or not issue here. Post the cutoff date.
exactly, Milord.
Therefore-
Exactly, Milord. In the Samaguri college also post cutoff date.
That we don't know, it's not clear from there.
No, Milord. If we go by the certificate, Milord, if we go by the certificate of the Samaguri
And
college,
let us assume that some mistake had crept in case of some college,
no, it is
not as per the provision.
Milord,
the law.
as per the provision of the law, it is permissible and possible also, Milord, because Milord, if we go by the provision of section 2H, Milord, my lord, I am referring to 2011 Act, my lord. If my lord maybe fine. My lord. Yeah, some Vansar educational institution, provincialization of services, my lord. Act, my lord, 2011. Section 2, my lord, definition H. It's employees, 649. It says, employees means and includes all serving employees, both teaching and non-teaching of the Vansar educational institution who have been appointed by the concerned Vansar educational institution before the first day of January 2011 and whose services are being or would be provincialized under this act. Now, if we go by the impugned speaking order, at page 110. Page 109, Milord. If my lord may come to the, maybe please to come to the bottom, Milord, section 2H, page 109. Means and includes all serving employees, both teaching and non-teaching of the Vansar educational institution who have been appointed by the Vansar educational institution before the first day of January 2011, whose services are being or would be provincialized under this act. By virtue of this provision, the case of MD Lukman Ali may be treated as an employee of Borkhetri College before 1/1/2011 as assistant professor, and all process of provincialization of service of MD Lukman Ali are to be made as assistant professor only due to his posting as an assistant professor in Borkhetri College before 1/1/2011. The aforesaid selection of MD Lukman Ali, obviously after 1/1/2011, that is on 4/6/2011, and such selection in no circumstances be provincialized as a principal as per provision, section 2H of the Assam so and so Act. The selection after 1/1/2011 cannot be taken into account to manage the affairs of the college where the services of the Lukman Ali process as assistant professor and not as a principal, by near of aforesaid provision of law. Therefore, this Lukman Ali as a principal cannot be made. It should be, my lord, as a provincialization cannot be made, but they have said that the selection cannot be made. Now, that if we go by the provision of section 2H, section 2H is very specific and clear. It is not post, respective. My limited understanding, is that it relates to if a person or incumbent is working in a particular institution or college, from the date of his initial appointment, that is in my case from 1994, till my upgradation or promotion as a principal of the said college, or a direct recruitment, my past service cannot be wiped out because of my higher absorption in the post of principal. Now they have given me the benefit of assistant professor, but they showing that as of the cutoff date is not supporting me, so therefore I cannot be given this benefit. That's why on the last occasion they did not deny this contention. They had targeted me that my PhD is not valid and eligible. That's why my lordship wanted to peruse the report from the higher education department.
What report?
The UGC report, there is a direction from this honorable court, to conduct the UGC and inquiry regarding my PhD also. And that report has not yet been placed before this honorable court or in any forum. That's why my respected friend Mr. K. Gogoi took time last occasion to place that report before this honorable court.
That report was not put before this honorable court as because petitioner withdrawn the petition laws.
No, after withdrawal
They
also,
withdrawn the petition laws.
after the withdrawal, I am finishing it. After the withdrawal also, there is a direction from this honorable court to go for the inquiry by the UGC. Even after the withdrawal.
You have completed, UGC have completed laws. That's why I am indicated laws first.
And there is also a direction to furnish a copy of the report to the petitioner also. But we have not received any such report till date.
Yes, because also that particular report was also on the basis of that particular petition that was withdrawn by the petitioner.
There is a direction to furnish a copy.
Final decision lordship is 8 lordship. Lordship?
Conclusion.
Conclusion lordship. When lordship, the committee was constituted by the UGC lordship.
Not genuine.
Lordship.
My lord.
It has not been issued by the university.
What my lord is saying, UGC has once inquired and found me genuine, my lord. That report we have.
And this was done lordship on the basis of our High Court order lordship.
You bring this on record.
Lordship, I will bring it on record. Lordship.
Along with the order by which direction.
Lordship, I will place all the annexers to the annexer itself indicated that particular order.
Higher education. Aspect of the PhD degree obtained by the one way.
One way.
Let it be listed immediately after.
My lord, may I pray for part third?
Part to get this further.
Pleasure.
Apply this matter again. Fifth of.
Pleasure.
Can it be on 6 or 7?
7.
7.
Mr.
Respond number 4.
3 and 4.
So 3 and 5.
Apply.
Extremely sorry, my lord. I was
context, and sorry, you have not seen this order. There is a specific direction for you to make a
Direction.
mention at 10:30.
My lord, in the event not received the case record, my lord.
Then?
I have received the record, my lord.
You have received.
My lord.
That should be mentioned here. The council you sent, you was not aware whether the records have been received, not received. What are these records relating to?
Relating to, my lord, we have filed our affidavit, my lord, stating that out of five petitioner, my lord, who are appeared before the screening committee, my lord, and others are not appeared, my lord. That's why the honorable court directed us to produce the screening committee report, my lord. So accordingly, I have received the record, my lord, and found that, my lord, petition number 1 and 2 are appeared before the screening committee. Others are not appeared, my lord. That's why, my lord, their records are not available in the department, my lord, as they are not appeared, my lord. And the petition of 1 and 2 appeared, my lord, so they are records are available, my lord. The Joint Secretary, my lord, returned to us, my lord, enter fact of the case. Can it peruse?
There is a claim for area salary. Claiming for area salary.
Area salary, my lord, they are initially appointed illegal and illegal kitchen.
Their own cabinet decision, they have approved the figure. So there was an inquiry, selection, screening committee, and screening committee suggested were to be appointed, will not be appointed. That way, cabinet has decided all such persons who were similar to the petitioners have already been regularized. So we post them, and their categorical statement was here, we have received salary.
These are your instructions. These are not records.
Yes, my lord, actually, I also told them, my lord, they have said that nowadays they are digitally, my lord, handling the record, my lord. That's why, my lord, they are.
Who told you that?
My lord,
Who told you?
the officer system, my lord.
Huh?
Department, my lord.
Who's been directed to produce the records? What? Director Elementary Education. Who is required to produce the records?
The records are produced by the government, my lord.
Government represented by who?
Commissioner Secretary, my lord, the cases.
So let us call the Commissioner Secretary, find out what is there. You are unable to produce the records.
That recorded sent
You
by
are receiving instructions from some officers who don't know what the court wants. Asking for the records, and you are giving us your instructions.
That was, my lord, I also,
they are not cooperating with you.
But my lord, but I think it may, it's on Friday, my lord. In the meantime, I'll
Friday.
The office assistant said that nowadays they are digitally, my lord, they have print out, they have given.
By order dated 12/5/2026, this court bench was of the view that it would be appropriate to peruse the records, proper adjudication of the matter. As the state affidavit filed, or as the affidavit filed on behalf of the state indicates that some of the petitioners did not participate in the screening committee for identification being illegal within or regular teachers as per the so records were accordingly called 17/6/2026. Council representing the elementary education submitted the report produced on the next day. The matter is called. The standing council has placed before the court. So, placed before the litigation addressed by the Joint Secretary, Department of School Education, to the Senior Secondary Senior Standing Council, Department of School Education. Along with some extracts of the report. This, according to the court, satisfy the requirement of production of the relevant record directed by the court. Accordingly, we permit the Standing Council one final opportunity to produce the relevant records pertaining to the issues raised in the writ petition for necessary production for the court. Based on
From my senior opinion. Take a look.
Monday next, 27th. 27th of July.
It is not a covered case, madam.
Not a
Here-
covered case.
Yes, madam. Here, my lord, the case referred, they my lord, appointed as assistant teacher in different upper primary school. Here, page 51. And having the graduate degree, my lord. But here in the petitioner,
Then you find your response here.
yes, yes. My lord.
Mr. A.R. Bhuyan, and City Council assisted by.
Yes.
Yes.
You,
Mr.
Sharma.
Ripu Sharma, here Standing Council appearing three,
Respondent number,
respondent, only respondent,
all the rest. Yes, all the rest.
submitted that they learned at City Council submits that the petition can be disposed of in turn. Passed in WPC number, order dated
No, the order dated 23/5/2025.
23/5/2025.
In WPC 2676 of 2025.
676 of 25.
Month.
Correct. Learned Standing Council, secondary education, however, disputes the same and submits the issues raised in the present petition. Stand covered. Still after 4 weeks.